All rise.
Be seated.
Good afternoon, everyone. The court would like to provide a friendly reminder that today's hearing is currently being live streamed for public viewing. This means that the entirety of this hearing, the courtroom communication can be heard by those over Zoom and live stream. Please be mindful of your professional decorum throughout these hearings, both on and off the record, as it may be heard by all viewing.
Okay, this is case number 1910 DC-1583, State of Nevada versus John Kelly O'Connor. Why don't the parties identify themselves and who they represent?
Certainly. Lane Mills on behalf of the state, Your Honor, Chief Deputy District Attorney. And with me is Senior Deputy District Attorney Chelsea Sanford.
Good afternoon, Your Honor. Richard Davies on behalf of Mr. John O'Connor. He's present in court to my right and in custody.
Okay. I have, I'm sure counsel has received, let me make sure I find it. Should have probably figured out where it was in the file before I came in. It's right on front, that's why I didn't find it. I have a report from the doctors in this case and the psychologist. One's dated, looks like July 8th, 2023. Let me see here. I have one from Stephen Zukowski, MD. One from Amy Patterson, PhD. And one from Debbie Fletcher, PhD. Have all the counsel received copies of those reports?
Yes, Your Honor.
Yes, the defense has.
Okay, so what's the plan? What are we going to do?
Your Honor, upon my reviewing of Dr. Zukowski's report, dated report is July 8th, 2021. The report says that Mr. O'Connor, I'm reading off the first page, Mr. O'Connor does not have a substantial probability of being restored to competency within the foreseeable time frame. Additional treatments and efforts are unlikely to result in trial competency. Sorry, just above that it says he does not have the present ability to aid and assist in his defense. I look at Dr. Patterson's report. It's dated June 24th, 2021. I'm looking at her very last page, 10 of 10. It is my professional opinion stated with a reasonable degree of psychological certainty that Mr. O'Connor does not have the present ability to understand the nature of the charges against him, to understand the nature and process of the court's proceedings, or to aid and assist his attorney's defense with a reasonable degree of rational understanding at any time during these proceedings. I'm also looking at the report from Dr. Fletcher. That date of that report is July 2nd, 2021. And the very last page, our summary and opinion says that Mr. O'Connor does not have the ability to understand the nature of the criminal charges against him, does not understand the nature and purpose of the court proceedings, unable to aid and assist in counsel in his defense. Despite his being treated, his mental health condition indicates it's unlikely he will achieve competency in the foreseeable future. In light of those three reports, Your Honor, I'm looking at NRS 178460. Direct the court to subsection 4D. If the judge finds the defendant incompetent with no substantial probability of obtaining competency in the foreseeable future, the judge shall order the defendant released from custody, or if the defendant is an outpatient release from the obligations as an outpatient if, within 10 judicial days, the prosecuting attorney has not filed a motion pursuant to NRS 178461, or if within 10 judicial days of petition has not filed to commit the person pursuant to NRS 433A200, after the initial 10 judicial days, the person may remain in outpatient or in custody under provisions of this chapter, only as long as the motion or petition is pending, unless the person is committed to the custody of the administrator pursuant to NRS 178461. So, at this point, Your Honor, I am going to move for dismissal for the information against my client, with the anticipation that Mr. Mills, Ms. Sanford will be filing their motion within 10 days of today's date in order to proceed towards commitment.
Mr. Lane?
Thank you, Your Honor. I think what the court was getting at is whether or not either counsel is going to be asking for a hearing with respect to this report under subsection 1. And our office has been in communication with Dr. Zukowski throughout the last few months about this. As the court will recall from the record, we previously had a traverse of the findings by 3 psychologists or psychiatrists previously, the first time. And we do not read these reports much different than those when we had those. And so we do not believe that a hearing with respect to that and having them appear would change anything from the report. So we will not be asking for that, Your Honor. With respect to...
So you're not asking for a hearing, is that what you're saying?
That's correct, Your Honor.
So you basically are agreeing what they reported, that he's not competent to stand trial, and
These are the state's...
is unlikely to ever become so?
Yeah, these are the state's doctors, Your Honor.
Okay.
And we have talked at length with them.
Okay.
As such, we will be filing, if the court does make that finding today, we will be filing a motion pursuant to 178461. We would love to take this to trial, but unfortunately, and this court knows, the Nevada Supreme Court has had a series of recent cases about competency of the defendant come down. But the Constitution does not allow for that when he's not competent. And so we will be filing a motion if the court makes those findings today to have him committed to Lakes. We have already sent the letter to Lakes for the evaluation by them that's to be accompanied for that pursuant to 461. There is a new statute under NRS 461 that some amendments to it in the last legislative session. I don't know if the court's aware of that. It changed some of the timelines. I do have a copy for the court if the court would like to see that.
Give me a copy.
Certainly.
I have Lexis, and I looked at all these statutes both in the Nevada Law Library and under LexisNexis.
It does not change substantially the process, Your Honor. May I approach?
Yeah, if you would. Do you have a copy of this, Mr. Davies?
178461, yes, I do have a copy here.
Do what I did. If everybody will excuse me, I think I set my glass. I've been using Stocker's glasses, and he's younger than me. I can't read. You be seated. I'm just going to grab my glasses. That's the thing when you try to use a young judge's glasses when you're an old judge. That's a lot better now. I can see. Talk about blind justice, huh? Okay, so it used to be 10 days, now it's 40 calendar days.
Yes, Your Honor. So it adjusted the parameters of the timeline. It does not change anything. And as such, obviously, we'll be seeking to have this defendant committed to Lakes, a secure custodial facility, and of course, under potentially in the subsection 8 of that statute, it could be for the entirety of his life. And so that's, we'll be filing that motion before the close of business today.
Okay. And that would be pursuant to that 178.461. Okay. So then, Mr. Davies, do you have anything you want to add?
No, Your Honor, I think I made my record.
So then, given that all the parties agree that what the psychiatrist and psychologist have said, I find that Mr. O'Connor is not competent to proceed with adjudication. In this case, it sounded to me more like that they found that he couldn't assist counsel because of some delusions that he has, apparently.
That's what I've read, Your Honor.
That's correct, Your Honor. My reading of it is that he understands the proceedings, more or less, but because of the delusions that he has, he wouldn't be able to assist counsel. So on that basis, I'm going to find him incompetent. And I'm also going to find that based on what the psychiatrist and psychologists have said, he is unlikely to become competent in the foreseeable future. And based on that, and your assertion that you're going to be filing that, I would be, do I dismiss the charges now, or do I wait until after the motion's been filed? We've considered his dangerousness to himself and or his.
I believe you dismissed the information now, and then the state has the window to file within, I thought 10, but I guess 40 days.
Mr. Lane?
It's within 10 days. And it's within 40 days that they have to have the risk assessment done. I'm not sure that the statute's clear with respect to the timing of it, Your Honor, if it's now or if it's at the conclusion of the 10-day period.
No substantial probability of attaining competence in the foreseeable future. The judge shall order the defendant released from custody. If within 10 days the prosecuting attorney has not filed a motion pursuant to RS 178.471. So my reading of that is that I have to, within 10 days of my findings today, release him from custody if the motion pursuant to RS 178.461 hasn't been filed. And so if it's filed today, then we don't have to worry about that. What we need to do is set a hearing then on basically, I guess, his danger to the community and or. So if I guess once we get to that point, then I release him or detain him based upon a finding of danger to the community.
Once we file the motion, Your Honor, there's a different clock that starts running, and we'll need to set a hearing. Once that's been done, we will file it today, though.
Do you want to prepare an order for me, Mr. Lane?
Certainly, Your Honor.
That's satisfactory and run it by Mr. Davies. So I'm not going to release him today. I'm not going to dismiss the charges. We'll accomplish that. It looks, sometimes as often as they tinker with the statutes, the legislature doesn't make them any clearer ever, as far as I can tell. And if I were just sitting on these kinds of cases, it wouldn't bother me so much. But it's every area of law that I sit in. So now, they blow into town and they change the statutes on family law that I have to deal with in Reno and Carson City and every other little area of law that I have to deal with. They, for some reason, feel a compelling need to their statutes, and I've been doing this for 44 years now. It's starting to aggravate me after that long period of time. I think we did pretty well without all of their additions. At least I thought we did back in the late 70s, early 80s anyway. Anyway, you file that today. We need to probably set a hearing date today with all counsel here on that. So we have, well, I don't know if we're going to be able to because we have to wait for them to come up with a report, don't we? They have 40 days. We want to try to set something maybe 10 days
We have to
after
send
that.
it. We have to send it within 10 days of them of us receiving it from them. So
Let's do
generally
this.
talking 50 days out. So if
Let's
we want to
set
set
it
a
here.
place marker, we can do that.
Let's set it here in 50 days out. It's going to be, I'm free in all of September. I don't think I have anything set in September right now.
That's what
Which is unusual.
40 days is approximately August 23rd.
Well, let's go 10 days beyond that. So let's go ahead and go first part of September.
Would be, the 6th would be 10 days from that, but that's the Labor Day holiday. If you want to look at the 1st, 2nd, or 3rd of September, which is a Wednesday, Thursday, or Friday.
What's the preference of council?
The first, second, and third of September, I'm in a jury trial hearing, so I'm gonna be going. It'll probably go that long too.
What about August 31st? Is that good for you?
That's when we start the trial, 31st.
And that's a Tuesday.
We have the afternoon as well. Or the 30th,
The whole week I'm in trial, that trial.
September maybe?
6th, or 7th.
The 7th is the Tuesday. Let me see what our afternoon looks like. At this point, the 7th, which is the Tuesday, there is nothing scheduled for the afternoon. It's from September 7th. September 8th. There is nothing.
How's September 7th?
That works for me. Thanks.
Okay, and if we haven't gotten the report within 40 days, what do they have to? They have to ask for more.
We have to ask for more time. I'm sure we would hear from them.
Then we'll vacate that date without any further court proceedings.
Ms. Clerk, that September 7th, is that at 1:30 p.m.?
That's what I'm going with. Is that good with council?
Okay, that's good.
And I know we have a trial date set in 2022, and we're gonna vacate that.
Vacate the trial date. Anything else by council?
Later.
If you could prepare me an order, more is better than less, Mr. Lane, so if there's things the administrator is supposed to put that in order.
Thank you, Your Honor.
And give him the 40 days. And then he's gonna have to let us know if he can't get it done in the 40 days. And then put in there what they need to do is determine whether he's, danger to himself or the community. The person as it is.
The comprehensive risk assessment, which indicates whether the person requires the level of scrutiny and security provided by a forensic facility.
Do council anticipate a hearing on actual witnesses or?
I guess it depends what they say.
Yeah,
I would schedule time for that potentially, Your Honor.
the afternoon, you think? So what if I need to issue orders for them, would council care if they appeared by Zoom, or
I have no objection.
would you have any objection to that, Mr. Lane?
No.
Okay, so if the psychiatrist or psychologist choose to appear, what they call it, audio visual, then we'll allow them to do that.
Check. So I should block that up from 1:30 to 5 o'clock.
September 7th at 1:30. Anything else we need to do?
Later.
Thank you, Judge.
Thanks for coming in. You can all be at ease. Takes me a while to do stuff, so no sense in you standing.
All right.
You can be good. You're good.